Hi, greetings. My name is Irina Maderembeth, and I'll be presenting my Law of Treaties assignment for the midterms on journal review. The journal that I'll be reviewing is written by Desidik Suraputra in Journal Hukum International, the 11th volume, and published in 2014. The journal title lists the Doctrine of Rebuc Stantibus and the Law of International Treaty. Thus, my presentation outline will be firstly discussing about the key issues in the journal, and secondly, the critics, my personal critics, and also the conclusions. So, shall we start by discussing the key issues at hand of the journal? Let's go back to the doctrine of Rebuc Stantibus. This doctrine provides the chances for parties who step out of the agreement on the legitimate basis of fundamental change of circumstances. When the doctrine of Rebuc Stantibus is applied, there are two possibilities that may happen. The first is if related parties agree to acknowledge that underlying changes which made it impossible to apply the treaty may happen, then they may dispose amicably. In this first scenario, it is shown that all the parties to the certain treaty has agreed that a certain fundamental changes happen, so they can dispose the treaty in an amicable way. But the second circumstances happen when an agreement that such fundamental change of circumstances has not been agreed, then the situation may result to party using and abusing this situation to escape carrying the Rebuc Stantibus. When this situation apply, then a legal dispute will inevitably occur. Having said that, a dispute may result from a disagreement of a certain fundamental change of circumstances that may invoked by one of the parties, then this situation may be difficult to be solved by the law. Because in this dispute, it may be utilized by the parties that have interest, which is currently disjustified by the status quo. But on the other hand, this situation may be a threat to the state party that aims for stability. So, the application of the doctrine of Rebuc Stantibus was firstly noticed in the First World War, where up until the 1914 has caused disputes due to states' reckless application of the certain doctrines. Two examples of the applications of the Rebuc Stantibus that has been misused by states is firstly that the doctrine of Rebuc Stantibus has been a justification for the annexation of Bosnia based on the Treaty of Berlin in 1878 and the Convention of Constantinople, which granted the right to Austria and Hungary to occupy or run the government. And also with the same basis of Rebuc Stantibus, Switzerland laid claim to plea for the 1909 treaty with Germany and Italy in regards to the railroad of St. Gothard, and in respect of this, Germany has granted its approval. So the application of Rebuc Stantibus principle by states in the European region continued after the First World War ended. So we can read it back to Article 19 that the Assembly may from time to time advise reconsideration by members of the League of Treaties which have become inapplicable, and the consideration of international conditions which continues much in danger of the peace of the world. So basically, after the Second World War, even though that the League of Nations has anticipated Rebus Stantibus in Article 9 of the Covenant, the International Commission decided to insert the Rebuc Stantibus doctrine to a certain formal international law, acknowledging that the doctrine has been accepted by international experts. Although, in the application, the doctrine of Rebuc Stantibus shall be limited to the definition of fundamental change of circumstances, and considering that international law does not have a compelling jurisdiction, therefore, the definition of fundamental change of circumstances shall be established. So, in drafting the codification of Rebus Stantibus doctrine, the international law resorts to three alternative doctrines that will be selected even further. The first theory implies that parties are presumed to have had in mind the continuance of certain circumstances. So, the definition of fundamental circumstances only based on the parties' agreement. And secondly, the second theory implies that international law shall place an objective role as a rule of law, prescribing that it is essential change of circumstances entitles any of the parties to require the termination of the treaty. And the third theory, somewhat mixed between the first and the second, including the elements of the agreement and also the role of international law as an objective rule. Therefore, the International Law Commission resorts to the second and the third theory, although they shall assess and distinguish both theories. And they found that the distinction between the second and the third theory is that the legal provision will prevail by inserting implicit requirements to the treaty. Therefore, if there is a fundamental change, the treaty will terminate automatically. That is for the third. Whereas, according to the second theory, it merely grants the right to the parties to terminate the treaty. However, the termination of the treaty is not allowed to be carried out unilaterally if there is any fundamental change of circumstances. Thus, the distinction between the second and the third theory is not that different. But the third theory is somehow supplementing the second theory. However, the International Law Commission decided to select the second theory, that the international law is considered to impose upon parties to a treaty an objective rule of law prescribing that essential change of circumstances entitles any of the parties to require termination of the treaty. The rationale behind this is that it merely grants the right to party to terminate unilaterally because they have to comply to the international law that have a role as an objective rule. So therefore, the manifestation of the codification of the doctrine can be seen in Article 59 of the draft articles of the law of treaties, and also in the VCLT that we know today in Article 62. Well, based on this elaboration, the author's conclusion say that the fundamental change of circumstances may result to an abuse, even if it's codified under the Article 62 of the Vienna Convention, because there is still a discussion and a debate on how to define exactly the thresholds of fundamental change of circumstances. Therefore, it is very risky to imply the Rebuc Stantibus doctrine because there's a lot of loopholes to be abused, and therefore the duty to define fundamental change of circumstances is not to be put on the legislation but also to the domestic applications of law. And now let's move on to the critics. So what I would like to critique about this journal is the concerns about the possibility of abuse. The author had set forth in the conclusion that even if it is codified, the Rebuc Stantibus may lead to an abuse due to the debate of defining fundamental change of circumstances. However, I would like to criticize that the chances of abuse or perversion is not likely to happen. How and why? Because the fundamental circumstances, although it's still in debate, the threshold is indeed high. We would like to trace back to the history that prior to the establishment of Rebuc Stantibus, as Hans Kelsen said, that the ground norm of making an agreement is pacta sunt servanda, which in a sense that a treaty is binding to the parties, that the purpose of the treaty is to be performed in good faith. In other words, escaping the agreement unilaterally may constitute a violation. The nature of Rebuc Stantibus opens the opportunity for state parties to step out of the treaty through unilateral manner, which is arbitrary to the essence of pacta sunt servanda. Thus, for Rebuc Stantibus to not violate pacta sunt servanda, there are some preconditions that needs to be established. The first precondition is that the change must be of circumstances which existed at the time of the treaty was concluded. The second, the change must be fundamental. And the third, the change must also be not foreseen by the parties by the time at the conclusion of the treaties. And the existence of those circumstances must have constitution and essential base of the consents of the parties to be bound by the treaties. And the effect of the change must be radically transformed to the scope of the obligation to be performed by the treaty. So a case example that may show how high the standard of fundamental change of circumstances is the Brexit. We all know that UK wants to leave from EU, and Geoffrey Cox, the Attorney General, once proposed to use Article 62 of the PCLT to withdraw from the EU. However, many lawyers in UK contend that this decision may lead to a hopeless result. Referring to a previous case settled in the ICJ in 1997, the case of Gabjikovo Nagimaro, where Hungary had claimed that fundamental change of circumstances happened due to profound political change in the region and to the economic system. However, the court ruled that it was not sufficient. Therefore, we can see that although Article 62 may give a loophole for abuse to happen, but we also have to see that the threshold of fundamental circumstances is very high, and there are a lot of preconditions that need to be fulfilled, and based on the precedence of the case, it only happens on exceptional basis. So, to conclude my presentation, it is true that on the journal that Rebuc Stantibus provides opportunity for state parties to escape a certain treaty obligation using the reason of fundamental change of circumstances. And yes, Article 62 may provide and support a loophole for this, but we also have to see on the other side that the threshold to achieve and to define and to prove fundamental change of circumstances is very high, acknowledging that there are preconditions that need to be fulfilled, and based on precedents, that it only applies on an exceptional basis. So thereby I conclude my presentation, and thank you for listening.